3. The Microsoft case. 3.1. What makes Microsoft a de jure monopoly? So-called intellectual property. Microsoft has always lived on a particular kind of government-granted privilege called intellectual property. Consider in the early history of Microsoft the article that first made Bill Gates famous, An Open Letter to Hobbyists, published in February 1976, to threaten with prosecution people who were freely exchanging copies of Microsoft Basic. Since the beginning, Microsoft claims a right to revenue not just from the services it actually renders, but from those it prevents competitors from rendering. According to their argument, people should not copy, use, modify, enhance, adapt, or redistribute software upon which Microsoft lays a claim of intellectual property, without acquiring a license by paying a tribute to Microsoft at Microsoft's conditions. I've discussed in my article on patents the evils of intellectual property, which I prefer to call by its true name of information protectionism. Though the article itself is more oriented toward the patent system, which is indeed considerably worse than the copyright system, upon which resides Microsoft's most valuable privileges, the general arguments mostly apply to information protectionism in general, and the bibliography contains many publications that tackle the case of copyrights, as well as the case of patents. To the contrary of the original trademark system, now also turned into a mess of government privileges, copyrights and patents were never born in either contract law or common law. Historically, philosophically, and from all that serve as their justifications, they are government privileges. Though licenses themselves may look like agreements, their force resides in the prohibitions issued by governments that confer some monopoly to intellectual property hoarders, and such monopoly granted by governments is itself a usurpation that binds unwilling parties that never agreed to them. What is in question is not the agreements, but the context of monopoly in which they are being proposed. This monopoly is not born in a contract. It lacks the essential liberties that define contract law: the right to denounce the contract and exit it, though it may cost you, the right to enter or not enter the contract to begin with, and the right to enter instead any competing contract from a different provider that you'd prefer. Just because monopolies are now issued by a parliament instead of a king doesn't make these privileges any less of the usurpations they are. Consenting adults are prevented from helping each other so as to confer a monopoly to the privileged title holder. To libertarians, any such forceful intervention into the life of any non-consenting third party is illegitimate. It is notable that intellectual property never succeeded in any public debate or open economic debate. Rather, it was imposed upon the world through the art of public choice policy-making through lobbying, buying privileges by funding friendly politicians. Legitimate property consists in securing the right of a creator to exchange his goods and services with customers for money, or with other partners for other services, at a mutually agreed upon price or conditions. But intellectual property is not this kind of legitimate property. Just like the alleged property title claimed by the Company of Indies on the trade of tea with America, it is a government-granted privilege that consists in preventing willing third parties from exchanging services with each other. To add insult to injury, Microsoft and other intellectual property claimants require the public to bear the costs of enforcing their claims upon the public itself. Intellectual property is thus artificial property, the enforcement costs of which are borne by those being excluded. On the other hand, natural property is precisely born out of people having the right not to what they claim, but to what they actually create and protect. Allowing some people to shift to other people the burden of protecting their property only results in political lobbies ever extending the cost borne by the general public for the protection of a privileged few, and excluding the same public from more and more claimed property that ought never to exist to begin with. In other words, the principle of protectionism is at work, through which the general public has to pay to be itself the victim of exclusions that benefit a privileged few. 3.2. An account of Microsoft's success. Microsoft is a software company that is successful for some of the software it develops and sells, but what Microsoft produces is not its sole or main source of revenue. What it prevents other people from producing through the legislated use of public force is much more so its main source of revenues. Or rather, its source of revenue is in combining as much protectionist privileges as possible into the services it actually delivers. Indeed, it does not follow from Microsoft being a de jure monopoly that it doesn't deliver valuable services. When the owners of protected industries of old and of new made and make tremendous profits out of the legislated scarcity of protected goods and services, the problem wasn't and isn't the goods and services they delivered and deliver. That and this tea, wheat, iron, coal, cloth, software services, etc. aren't and weren't useless goods and services that people had to purchase against their will. Quite to the contrary, they were and are most useful goods and services that people seek to purchase in the greatest quality and quantity and at the lowest possible price. The problem is that protectionism creates an artificial scarcity, expensiveness, and lack of quality that customers have to face when purchasing these goods. As usual, the problem with monopolists is not what they deliver, which is seen, but what they prevent other people from delivering, which is not seen. In its owing most of its revenues from racketeering the public with the help of government privileges, Microsoft is not the only privileged party on the market of computer systems. It is interesting to study why Microsoft has succeeded so tremendously as compared to the other similar de jure monopolies, and why it has become a de facto monopoly where others have failed. Actually, just like the US government succeeded by racketeering the country under its domination less than most other governments racketeer their own, Microsoft succeeded by racketeering the software market under its domination less than any other system software publisher. All other computer system vendors try to tie their software and hardware offerings. By a serendipitous series of events, Microsoft found themselves holding a software monopoly on a puny computer line that IBM had failed to secure as a hardware monopoly, the IBM PC, at a time when the cost of computer hardware vastly exceeded those of computer software. In a few years, competition among hardware vendors turned this miserable and expensive computer platform into the greatest computer industry of all time. Other people have tried to produce systems protected by intellectual property to rival Microsoft's MS-DOS and its successor Windows NT, but Microsoft had to compete to remain the most attractive among the privilege holders, while using part of its privilege revenues to stay ahead of those competitors who didn't use privilege and profit from monopoly rent. Remarkably, for all its defects and all the misery it spreads over the world, we must thus reckon Microsoft as the current best thing that the market could bring in a world where information protectionism rules. This seemingly paradoxical fact is but another consequence of the market working despite the hurdles of coercive government intervention. Now, Microsoft being the best of a protectionist world mustn't make us forget all the destruction of competitors' efforts upon which its de jure monopoly is based. The privilege of information protectionism is rather abstract and its effects are indirect, but they can be clearly seen if one has a basic understanding of the dynamics of software development. The main privilege that information protectionism confers is vendor lock-in. Customers, once they picked the monopolist that will supply them, cannot switch to any competition, or they cease to be able to reuse their existing documents. And the secret of Microsoft's success is that they found a way of extending this lock-in to all the suppliers on the PC market by pricing their software on the basis of all of a supplier's product line, making the use of any other software marginally unattractive, effectively preventing any rival software from ever being sold with a PC. They thus leveraged their de facto dominant position into a de facto monopoly, in itself not a bad thing, based on their de jure monopoly upon the dominant software they were selling. Advocates of information protectionism will claim that in their system there can still be competition on products, despite the legal hurdles by which they prevent this competition from reusing protected components. But even if a competing product is compatible today, you can't be sure that it will remain compatible tomorrow, because the vendor can introduce gratuitous incompatibilities, undocumented features, bugs, etc. Moreover, the competition will have to incur tremendous engineering costs and delays if it is to remain compatible, and those costs are capital that can't be invested in making useful enhancements that actually bring value to customers. Information protectionism actually implies that one can't make long-term plans based on improving or servicing proprietary software held by someone else, assuming that one finds a way to do it legally at all in the short term, to begin with. If the vendor explicitly provides a way to plug in additional software, then one may develop such plugins, but who knows if in the next version they won't remove the plugin interface, make it incompatible, or provide their own plugin for that functionality, etc. One can't build long-term plans of production in these conditions, so one is trapped in short-term plans, unless one practically becomes a subsidiary of the vendor. Intellectual property hoarders effectively claim, and are granted by government, not just a monopoly on their past creation, but a monopoly on the creation of anyone who dare improve on their past products. In any case, the de jure monopoly leads to a de facto monopoly by preventing competing services or original offers from surviving or from even emerging at all. The greatest damages caused by a monopoly like Microsoft are thus not the visible damages against Netscape, or against any competitor that was led to bankruptcy or insignificance. The most important victims are not those who wrote software that was actually outsold by Microsoft products. Rather, the greatest damages caused by Microsoft are the invisible damages against all those competitors that did not appear. The most important victims are those who could not write new software or enhance old software, and those who could not enjoy that unwritten software. The authors of DR-DOS and BOS were victims, but they were victims for the code they didn't write more than for the code they actually wrote. Also victims were all the authors that couldn't gather funds for rival operating system projects, and all the Microsoft employees who thought of ways to offer better service than their management led them to, yet could not split and offer these better services because of Microsoft's de jure monopoly on said software. The greatest loss caused by protectionism is all the good things that never ever happened, because privileged people do not earn money by building new useful code upon old code, but instead by preventing each other from building new useful code. All the efforts wasted in destructive strategies instead of constructive endeavours, all the great inventions and cheap services that did not happen and can't be seen, this is the greatest loss due to information protectionism. The fundamental principle to be understood is that all real costs in economics are opportunity costs, and the very principle of a de jure monopoly is to prevent any opportunity from ever appearing. Behind any de jure monopoly, there are the benefits for the monopolists that are seen, and the losses for the consumers and excluded competitors that are not seen. And indeed, the latter negative effects not only can be predicted, but constitute the very reason why monopoly protection is being sought from the government and granted by politicians in exchange for political support. 3.3. The role of government. Nowadays, government poses as the saviour that promises to protect the people from the economic power of private monopolies. But putting aside the propaganda, what role has government actually taken in this affair? Has it really been protecting us from monopolies? No, not at all. The first and foremost role played by government has been the enactment of the very monopolies against which it claims to protect us. The only illegitimate power that exists is the government's own political power. The distinction between public and private is an irrelevant accounting fallacy, and all the de jure monopolies are born in government protection. Legislated regulations granted by parliaments of politicians may have replaced personal privileges granted by kings, but under the modernized form the principle is always the same. The new privileges are more subtle, they are more concealed from the eyes of the economically ignorant, and they even deflect the anger of the masses towards free market capitalism, but they are stronger than ever. The origin of Microsoft's monopoly is government intervention in the form of intellectual property. The times of kings are ended wherein the sovereign could grant and revoke nominal privileges to anyone who'd please him, out of his whim and his might. Nowadays, politicians may only institute privileges by enacting legislation, and the might on which resides their political power, by very definition of any political power, must now hide under the pretense of law. Despite what some people argue, just because the laws instituting privileges aren't nominative doesn't make them any less privileges. If a king, after raiding a town and enslaving all its inhabitants, organises a contest among his knights, the top prize of which being that the winner will choose and be granted one captured slave most beautiful to his taste, This gift isn't less of a usurpation by not being nominative and by being based on a competition with well-established rules. What makes it a usurpation is not the way the king recruits his knights and organises with them to fight and to share the booty. It doesn't matter whether the political entity is led by arbitrary whim or through abstract rules, whether its organisation is efficient or inefficient. If, during their conquest, the knights from town to town have come to consider the contest and its many prizes as a right they possess, and the king finds himself dispossessed of the right to institute and revoke such a contest, then the contest isn't more legitimate by being based on a rule rather than on a whim. Those who discuss such matters utterly miss the point. The gift of part of the booty is a usurpation because the booty itself is based on aggression, theft, murder, enslavement, etc. Intellectual property laws are indeed a much more efficient way to distribute privilege than granting patents to publishers and manufacturers who please the king. It indeed doesn't depend any more on the whims of the topmost rulers of the country. Its aggression requires less direct deaths. In the wealthy societies of today, the fear of fines, confiscation, and prison is enough to discourage most anyone from overtly opposing the rule of the new tyrants. But the fact that oppression can be done in ways that are smoother, softer, more efficient, and better organised through abstract rules doesn't magically conceal the oppressive nature of its aggressions. It is indeed interesting that in our times, where the absolute democracy of popular right has replaced the absolute monarchy of divine right, government, the nominally topmost political authority, loses the benefits of the privileges it grants, though the privileges are still as much usurpations as they ever were. Thus, to earn their share of the booty, politicians must constantly manoeuvre so as to invent new kinds of privileges and sell them against support from special interest groups, and new menaces against established privileges as well as against legitimate property, so as to sell their protection to those who are threatened of dispossession. This is how we can interpret the masquerade of government prosecution against Microsoft. It was never aimed at reducing government intervention. The prosecution never proposed to do anything about the root of the evil, that is, the intellectual property privileges that institute a de jure monopoly. Such a topic never even appeared in the case, and any party who'd proposed to help prosecution with an argument in this direction was dismissed by the prosecutor before any hearing. The goal of the Clinton prosecution of Microsoft was to extend government intervention, to make it more subtle and stronger. The proposed solutions were never about reducing a tiny bit of the privileges granted to Microsoft, or whichever institution would have replaced it. They were all about constituting new privileges. And the whole political endeavour failed precisely because the politicians didn't find a constituency or special interest group to be bought by extorting money from Microsoft. Therefore, in this story, we may view the respective roles of Microsoft and the government as those of a racketeer and a vandal. Microsoft levies its racket money from all those who are prevented from freely exchanging services, copying or enhancing software, etc. Microsoft managers are racketeers. Government creates de jure monopolies that are detrimental to the public, without the politicians that cause this destruction benefiting much, if at all, from it. Politicians are vandals. Moreover, Microsoft is an efficient racketeer, successful in a market where the public is still free to choose to which monopoly to surrender a rent, whereas government was an inefficient vandal, the mother of all monopolies, that lives out of plunder and privilege granting, yet only manages to grab for itself but a tiny part of the plunder made possible by the destruction it unleashes. 3.4. Monopoly Justice. Government is the vandal that lives by selling our rights off to the racketeers. Hence, when in a case like the Microsoft case, government champions a cause in courts, just like with all other causes it champions, it is actually fighting the symptoms of the evil with even more evil. It is proposing new interventions as solutions to problems caused by its own previous interventions, thereby both extending its power and creating the conditions for ever more problems that will require ever more intervention to solve them. The selection pressure for governments is to define policies that have the appearance of solving a problem while creating more problems that can't be directly traced to the former, and allowing them to generate revenues that can be sold off to special interest groups. Thus, what government will never ever do is to challenge privileges before a court. Government isn't bloody likely to ever sap the very principles of its power, distributing privileges. If people did realise that privileges are revocable by a court, then government would lose all the power it has. Government will never question privileges in court, and will deny courts the right to question privileges to begin with, making them instead instruments of the defence of privileges. The government-controlled justice system serves to uphold government-instituted privileges, whether they benefit to private people or to public administrations. The justice system can also serve to help the government find those privileges that the public is ready to endure, or the shape of which fools the public into embracing them, as opposed to privileges that appear to the public as worthy of revolting against. And indeed, one of the main ways in which government intervenes to establish monopolies is the way that it organises the justice system, by making justice itself a monopoly, and by making government legislation the basis for decisions of justice. In democratic times, people are theoretically equal under the law. Now, not only do political connections negate this theory, but the law isn't equal for all people. It is made to benefit some to the detriment of all, albeit in subtle ways invisible to those uneducated masses who don't see beyond the appearance, and are subject to omnipresent propaganda to keep them ignorant and fill their heads with prejudice in favour of government intervention. What government does to the justice system is actually one of the main damages it does to society. Not only does government plunder society to the benefit of special interest groups, it also corrupts the mechanism by which people adjust their behaviour to achieve peaceful and just social interaction. Instead of the justice system defending those principles and laws that the public really deems as just, as would emerge from a free system of justice where everyone would support whichever among competing justice providers best reflect his opinions, it instead is made to serve the interests of political power to the detriment of the public. It is made to defend unjust laws that have no public support, but powerful lobbies in the capital city, and to fail to defend just laws that would have public support, but no lobbies in Washington. Actually, when a government achieves monopoly on the legal use of force in a country, any injustice is the inevitable consequence of its interventions, as well as its passivity, whether it is the justice directly created by government or indirectly made to happen by the government's failure to end injustice created by others, all the while actively preventing the victims from defending themselves. This is why government is evil both by its activity or its passivity. Or rather, the evil of government isn't in what it does or fails to do. Its evil is in its very nature, and has its root in its usurpation of power. In other words, by monopolising public force, the tool that warrants enforcement of justice, government assumes the responsibility for any and all uses of force, or lack thereof, and thus for any and all injustices that appear or remain in the country, whether or not these injustices are privileges explicitly instituted in written law.